Good morning or good afternoon, depending on where you are joining us from today. I am Nancy Barnes. I am a labor and employment partner with Thompson Hine in our Cleveland office, and I'm the head of the Thompson Hine's Labor and Employment Practice Group. Welcome to today's webinar. I'm delighted to introduce the colleagues who will be presenting with me today. I have John Weimer, who is a labor and employment partner in our Atlanta office, as well as Debbie Brenneman, who's a labor and employment partner in our Dayton office, and Kim Wilcoxon, who is a partner in our Cincinnati office and is a member of the Employee Benefits and Executive Compensation Group. For the next 90 minutes, we will review the recently issued OSHA Emergency Temporary Standard called ETS that provides COVID-19 vaccination, testing, and masking regulatory requirements for workplaces with more than 100 employees. We will talk about some practical advice for planning to comply with those requirements, and we will discuss the impact of pending litigation on the ETS. And finally, we will also be discussing the interplay with various benefits issues. Due to the large audience that we expect to have on this call, I think about 400 people are registered, and the amount of content that we are presenting, we may only have a short time for Q&A. We do encourage you to put your questions in the chat box, and we will address them with whatever time we have remaining. We also encourage you to contact your Thompson Hine lawyer with any follow-up questions that you may have after today's webinar. And to proactively answer a question that we often receive, we are recording today's webinar. We will send both the recording and the presentation slides to all registrants within the next 2 business days. We know that this is a lot of material to cover, so we are going to be going fairly quickly through the next 90 minutes, so please buckle up. Thank you for your interest, and now we will begin the webinar. Okay, so on our agenda today, we are going to be talking about, obviously, the ETS. That's the focus of this webinar. There are some related regulations that you may impact your particular company, but the focus today is on the ETS, what it requires, and who does it cover. We're also going to briefly touch on the litigation landscape. We'll talk about planning for compliance and enforcement. We will also touch on issues dealing with unions for those of you who have collective bargaining agreements and operate in a unionized workplace, and we will discuss benefit-related issues. So first, a quick overview of OSHA's ETS. Large employers, which OSHA has defined as 100 or more employees, must require that employees be vaccinated, or they may choose to allow unvaccinated employees to test weekly and wear masks in the workplace. We're going to touch on all of those different provisions in just a second. The ETS became effective on Friday, November 5th, 2021. Most of the provisions that are included in the ETS, assuming that it is not stayed, will be enforced starting on December 6th, 2021. That's an update. They moved that date to make it on a Monday. And then finally, full enforcement, again, assuming that the ETS is not stayed, regarding the testing and vaccination requirements will become effective January 4th, 2022. And it will be in effect for 6 months. So let's talk just very quickly. This is a complicated subject, federal versus state OSHA. OSHA doesn't actually have jurisdiction over every private employer in the US. There's a distinction between the states that are governed by federal OSHA versus the states that have a state plan for OSHA. So if you are operating in multiple jurisdictions, you may already be aware of, whether you have a state plan or whether you have a federal plan, but be aware that there could be different OSHA ETS kind of regulations that apply to different workplaces in your organization. The federal government enforces those safety rules in the 29 states, plus the District of Columbia and American territories that are covered by federal OSHA, and then the remaining 21 states are under state plans. So one of the things to remember is that the federal OSHA standard that's currently been put in place, and we're going to get to the litigation in a minute, that federal OSHA standard is a floor. States who have state plans can have additional restrictions that go above and beyond what the federal ETS requires. All right, so I'm going to ask Debbie to talk a little bit about the litigation status. I know a lot of people have questions about this, so we're going to give you a brief overview of where that stands.
Yeah, the first question everybody has, I'm sure, is this really going to matter? Because you've seen all of the litigation activity that's taken place. So let's just take a look at that for a few moments. There have been a number of lawsuits filed in the circuit courts in a variety, and some more today, which I'll talk about in a moment. And they've espoused a number of theories. Some of them have been that although Congress delegated broad authority to the Secretary under the Act, that power should be narrowly circumscribed and that this is overbroad. The Act authorizes OSHA to issue an ETS to protect employees from exposure to substances, agents, and hazards. Some of these cases suggest that COVID is not the type of substance, agent, or hazard that supports the issuance of an ETS. An ETS must also be necessary to protect employees from grave danger. So some of the lawsuits argue that the ETS is not necessary, that there's not a grave danger. And then there are some technical arguments too, like there was no process allowing public comment on the rule. And still others of the litigation assert that the power to compel vaccinations, if it lies anywhere, lies with the states and not with the federal government. So we saw that the Fifth Circuit was the first circuit to really speak out on this. The circuit swiftly issued a stay in reaction to a lawsuit filed by a few states, as well as some private individuals and a variety of different businesses. This was a two-page order. It doesn't give a lot of insight. It doesn't say whether it purports to stay this nationwide. It just cites grave statutory and constitutional issues. And it set a very quick briefing schedule. So the administration was ordered to file a response by Monday at 5 p.m. The petitioner's response was due at 5 p.m. yesterday. So anytime we could get some response from the federal court. But what even does that mean? Maybe everything or maybe nothing. There's a unique quirk that under federal law, two things. First of all, it allows these challenges of OSHA rulings to bypass the district courts and go right to the circuit courts. And there's also a provision that dictates that where there are a number of these cases, they can be consolidated and heard by one federal appeals court that's chosen by lottery. So a very solid process there. It'll be chosen by lottery, probably sometime around November 16th, according to the Justice Department. But we do certainly expect a ruling by the Fifth Circuit before that time. So there's some debate about what exactly that means. Certainly if the Fifth Circuit is the one circuit chosen in the lottery, what it says will go. If another circuit is chosen, it can make a completely different decision or modify that. I will let you know that just today, a number of unions filed their own lawsuits in the circuits that are more liberal leaning, including the Ninth Circuit, which is, governs California and other geographies. So they're trying to ensure that there's a good portion of liberal courts in that lottery process as well. Ultimately, everyone is almost certain that this will end up in front of the Supreme Court, but the timing of that is a little tricky. And what, of course, do you do while this all plays out in the courts? Well, the best advice is to take a look and see what you need to do, because likely a decision is going to come very close to your deadline of when some of these things have to be in place.
Yeah, so we're gonna move forward with the webinar, assuming that some or all of these provisions are going to go into effect, and so talk about the things that you need to be thinking through in terms of compliance and making decisions about how you're going to handle this in your particular workplace. So the first question is, are we covered? Everybody knows about the 100 employee threshold. What people don't necessarily know is, well, who's in and who's out when we're counting employees. When you are counting employees, and this is a different situation than who actually has to comply with the vaccination and testing requirements. Right now, we're just doing our head count to determine, are you a covered employer? Employees who you are counting, obviously your full-time employees, but you're also counting your part-time employees, your seasonal employees. So if you're somebody who's hiring for the holidays, Your seasonal employees are going to count. They're temporary employees. They're only being hired for the 6 weeks between, Thanksgiving and New Year's. Doesn't matter. They're counted. They're remote employees. They work at home every single day, 365 days a year. They still count. If they are minors, so under the age of 18, they also count. They are an employee. And be aware that some of these issues with respect to medical concerns, testing, et cetera, when it comes to minors, if you do have employees under the age of 18, you may have additional requirements under state law regarding getting parental consent for some of these issues. So just keep that in mind if you're dealing with that situation. The people who you do not have to count as employees, independent contractors are not your employees for this purpose. Employees who are employees of a staffing agency, even though they are working at your particular location, they are not your employees. The staffing agency will have to do its own head count to see if it is covered. If you are in a franchisor-franchisee relationship, the employees of the franchisees are separate from those of the franchisor. If during the time that this ETS is in place, if your organization is ever greater than or equal to 100 employees, you are covered until the ETS expires. So if you had 100 employees on November 5th and you fortuitously went into a RIF on Monday and you now only have 90 employees, you are still covered. So it's once you cross the threshold, then you are under the ETS. Okay, one question that people had before this was issued is it going to be counted by location? That is not the way it is. It is under your corporate entity. And if you have 2 or more related entities, a lot of people have this question, are they going to be a single employer? This is a very fact-specific analysis that you have to do. But what the ETS says that it's going to focus on when there are related corporate entities is our safety matters handled essentially as one organization. And if that's the case, that's going to be a factor that weighs very heavily in favor of the separate corporate entities being treated as a single employer. So you can look at, do you have one EHS director? How have you handled prior OSHA inspections? How do you handle workplace safety matters? Do you have a single policy that applies at all those different entities or locations? Those things are going to mitigate in favor of your sort of having a consolidated operation. And OSHA's been very clear, the Biden administration has been very clear, they're trying to have as much coverage as possible. So if there's a way for them to shoehorn your organization into the 100 employee organization, you're going to be covered. So I would not try to stretch things and assume that you won't be covered. Your assumption should be, we're probably covered unless you have some really good arguments to say otherwise. Okay, what are some exceptions? Federal contractors and subcontractors, we're going to talk about this in a second, a little more detail, even though that's not the focus of this webinar. And then healthcare workers that were covered by the emergency temporary standard that was issued in June of 2021. They are not covered by this ETS. And the idea behind that is to basically have any specific employee only covered by one particular ETS so that there aren't sort of conflicting standards to the extent possible for a particular employee. If you are somebody with a federal contract or subcontract, you're probably familiar with Executive Order 140442, which was issued last month to deal with federal contracts for services and or construction, which are entered into on or after October 15th of this year or renewed or extended on or after that date. So there's actually a lot of federal contracts out there that are not covered under this particular provision, just that specific element. If you are covered, and we're going to talk about some other things in a second that relate to this, but if you are covered, it does impose a vaccination mandate on those contractors, as well as you have to adhere to the Safer Federal Workplace Task Force safety protocols. There is no testing alternative under the executive order other than for people who are in need of an accommodation under federally recognized accommodation principles, and Debbie's going to talk a little bit about that. The COVID vaccination is mandatory for all covered contractor employees. So most people would expect that that would include the people who are actually working on the federal contract or subcontract that falls within the executive order, but it also covers those who work in connection with that, meaning support personnel, work at a location where the employees who are covered by either provision number 1 or provision number 2 are likely to be present. So it's a pretty broad array of people, not just those who specifically work on the federal contract. The deadline for full vaccination is January 4th, 2022. That was extended, so it now aligns with the OSHA ETS. Okay, so again, the OSHA ETS does not apply to workplaces that are covered by the executive order, but the OSHA ETS will apply to any other workplaces that are not covered by the executive order. So there are certainly those of you on this call who are going to have a mixture of workplaces covered by one standard and workplaces that are covered by the other standard. Okay, let's just briefly talk about vaccination requirements. The ETS has defined fully vaccinated to mean 2 weeks after the individual's second dose of the 2-dose series, so Pfizer or Moderna, or 2 weeks after a single-dose vaccine such as Johnson & Johnson. The vaccines that are approved by the US FDA also count, as well as any vaccinations that are approved by the World Health Organization. So you may have some people who are vaccinated abroad with something else, that would count as a vaccination. Boosters are not included within the definition of fully vaccinated. So at this point, at least, you're not going to have to track boosters or who's had them or who's supposed to have them. Those are not part of the vaccination. Natural immunity, people who have had COVID, also that does not count as being fully vaccinated. Testing. Okay, this is probably everybody's biggest headache, is trying to figure out what they are going to do about the testing requirements, because almost every workplace is going to have some people who are likely going to be tested. So even if you have a mandatory vaccination policy in place, whether you have one voluntarily, whether that's what you elect to do under the ETS, whatever the reason is, you're very likely to have at least some people who are requesting accommodations, again, that Debbie's going to talk about due to medical reasons, disability, religious accommodations. So you're likely to have some people who are testing. If you choose to include a testing option for those who are unvaccinated, then obviously you're going to have probably a larger swath of your employees who are going to be subject to testing requirements. So the COVID-19 test must be approved by the FDA. It has to be administered according to authorized instructions. And if they're doing a self-test, which is sort of like the at-home test, it cannot be both self-administered and self-read. So they can't do it at home on the weekend, bring it into you and say, look, it's negative. I'm good to enter the workplace for the coming work week. So while at-home or over-the-counter tests are permitted under the rule, it has to be proctored. So it can be done either through telehealth with their healthcare provider or someone else, or it can be done or observed by the employer. So there is the possibility of doing that in the workplace. You can do pool testing, which is a new term for me. I feel like I'm an epidemiologist now, but pool testing is something where you can combine specimens from multiple employees into a single test. And if that test comes back negative for those 4, 6, 10 people, however many people are pooled, then it's negative for all of them. And basically you only have to run it through the lab one time and you get 4, 6, 10 results, whatever. Obviously, if it comes back positive, at least one of those people is positive. And so then you would have to retest each of those people individually. An employee must present proof of a negative test result. So this is important. It's not enough that on Sunday they went to CVS and took the test. If they don't have the test result, let's say Monday is the day for the 7 days to expire. If they don't have the test result by Monday, then they're not meeting the requirements of this rule. Testing has to happen every 7 days, or for employees who are frequently working at home and who are not in the workplace, let's say they come in once a month for a sales meeting, they would have to test 7 days and have the results 7 days before they're coming into work in the workplace. So positive tests. Part of your written program, and again, we're going to talk about some of the documentation and policies that you need to put in place. An employer must require employees to report positive test results, regardless of their vaccination status. So this doesn't just apply to your unvaccinated employees, it applies to all employees in your workplace. If they test positive, they must report it, and then you have to follow the CDC guidelines for when they can return to work after a positive test. Okay, people who are not required to test. Number one, an employee who has tested positive for COVID in the past 90 days. They do not have to test in that time frame, but they still must wear a mask in the workplace. There may be people who need accommodations, again, based on disability, religion, etc., who cannot test, and they also will not be required to test, although it's unclear exactly whether or not you can come up with a reasonable accommodation for those individuals. Okay, Debbie is going to touch on some of the PTO and sick leave provisions that are included in the ETS.
Yep, thanks, Nancy. And guess what? You are going to be paying for it as an employer. So under the regulations, the ETS requires that covered employers have to provide up to 4 hours of paid time off to receive each primary dose. Doesn't include the booster, but each primary dose, and reasonable time off for any side effects, which we'll talk about in a moment. Now, the vaccine time pay requirement is pay for time off work. And what that means is you might be able to minimize that paid time off if you as an employer establish an on-site vaccine clinic. So if you have something on site, if the employee goes there during their normal work hours, obviously it would already be included. If it's something they do before or after work, then it would you would add that time. If the employee for some reason decides to go on the weekend and get the vaccine and doesn't do it during the regular work hours, then you are not required to pay for that for any time to get the test or get the vaccine itself, but you would still be on the hook for any time that's required in terms of reactions to the vaccine, which we'll talk about in just a moment. Now, in terms of the mandated compensation for side effects, that can run concurrently with your existing sick time. So if you have a PTO policy that employees use to cover absences, then that can run concurrently with that. You can count that from the bank. But if you just have a freestanding vacation pay policy, then that can't be used. You have to provide additional sick time for those employees, again, to take the vaccine. We'll talk about how some of this plays out in terms of your policies as well. The ETS also has this requirement that you provide some paid sick time for vaccine side effects. Now, the regs themselves only require that the amount of time be reasonable, and it doesn't really tell you what reasonable is. If you look at the FAQs that have been issued, they say that sort of presumptively a 2-day amount of time would be considered reasonable, but you have to be flexible. So if someone has a sore arm or they feel like crap for a day or two, then the 2 hours is presumptively reasonable. But if you have an employee who has a significant medical reaction to it, that would not likely be viewed to be reasonable. So that's something that you want to make sure you don't set specific timeframes probably in your policy. You want to talk about it internally. You want to be consistent, and you're probably going to want to confer with counsel in terms of providing that reasonable time off for any employee who has a side effect.
Okay, and then on to wage and hour issues and the expenses of the actual test. And this is something I'm sure a lot of you have questions about. We've gotten a lot of questions about this so far. And unfortunately, the guidance is not super clear on this. We can share some things that are things you probably should follow or must follow. And then hopefully there's going to be some guidance coming out of the Department of Labor on this issue, the wage and hour division. So under current DOL guidance, employers are required to pay the time that employees spend waiting for or receiving medical attention, including COVID-19 testing, if it's done on the workplace premises or during working hours, and that's under the Fair Labor Standards Act. So this likely, we believe, includes required testing that occurs on an employee's day off, if such testing is quote unquote necessary to perform their jobs safely and effectively during the pandemic. My personal belief on this is that with the ETS, there's sort of an assumption that this is part of having employees perform their jobs safely if they're not vaccinated. And so my personal belief is that this is very likely to be something that is required to be paid under the Fair Labor Standards Act. I don't know that for sure, but we are supposed to be getting some additional guidance on the impact of the ETS on federal wage and hour laws. So that's certainly an issue that we're going to be tracking, as I'm sure many of you will be too. But the other issues to consider here are state wage and hour laws, as well as collective bargaining agreements or any other contractual provisions that you have. The ETS itself completely stayed out of the whole idea of whether you have to actually pay for the employee's time related to the testing, but it specifically identified, hey, there are probably some other laws out there that you need to look at to determine whether or not you have to pay people for that. One option that some of you may be familiar with in terms of having hourly employees where maybe you have different rates of pay for different activities. Some companies do have different rates of pay, for example, for travel time as opposed to time that an employee is actually performing their job function. That is something that you could consider. Is paying people at minimum wage for the time spent related to testing activities, but that's something that would need to be communicated to them in advance. Again, you could consider whether you want to do the testing on site so that you can more accurately track, did it take somebody 5 minutes before they started their shift to do their testing, or, was there a huge line and it took an hour, et cetera. As opposed to somebody saying, I spent the weekend driving around to 5 different places, there were long lines, and it took me 4 hours to get my testing done. Payment for the expense of a test. Ooh, this one is tricky too. So the ETS says that the employer does not have to pay for that, but is that really going to be the be all or end all as you're trying to decide what are we doing here as far as implementing a testing regimen? First question I would say, and sort of your flow chart of questions to ask is the testing being provided as an accommodation, a legally required accommodation for somebody's disability, medical condition, or a religious accommodation? If it is, then you should, as the employer, should be paying for the test, unless you can demonstrate particularly under the religious accommodation, that this is an undue burden for you to have to pay for the test. That could be the case for some employers, particularly if you have a high percentage of people who are not vaccinated and they are able to present sufficient documentation or responses to you to suggest that they have a religious accommodation. The cost of doing weekly tests for a huge swath of your population may be something that you can demonstrate as an undue burden. And again, Debbie's going to talk a little bit about that accommodation process. But that should be your first question. If it's not an accommodation, then what are the other issues you have to think through? You have to think through Fair Labor Standards Act, minimum wage, overtime issues. Is somebody paying for this test? Is that going to take them underneath what the minimum wage is for their time spent working this week? It's going to partially depend on what's the expense of a test, and if they're being paid minimum wage, so even something that costs $1 is going to take them under the minimum wage, that's potentially going to be a problem. You also have sticky state law issues about whether medical tests that are required for work are some type of reimbursable expense or are a medical test that the employer is required to pay. So certain states are a little more clear on this: Illinois, Pennsylvania, Kentucky, New Jersey, California. I would say if you're operating in those states, the best advice is that the expense of the test is going to be borne by the employer. In Arkansas, strangely enough, they've passed a law that says that employers are not responsible for COVID testing and that cost is to be borne by the employee. That law goes into effect January 13th, 2022. So in Arkansas, strangely enough, they're very specific about it. And then there are probably another 15 states that have some form of rule related to the expense of the actual test, whether it falls under business expenses, whether it falls under medical testing. And in some cases, it sounds like, oh, it's only the medical exam prior to your pre-employment medical exam that an employer must pay for. Other statutes have things that just generally refer to medical tests, and so it's unclear whether or not that's specifically going to be required in those states. So there's definitely some gray area there depending on what state you're in. So that's certainly, if you're thinking about having your employees pay for the actual expense of the test, you need to think through what jurisdiction you're in, and then is it worth the headache if you're in multiple jurisdictions to have some people paying, some people not paying, etc. Okay, we've been hinting at the accommodations and exemptions that are available. So let's hear from Debbie on those issues.
Yeah, thanks, Nancy. As with everything, it applies to everyone except, and there are exceptions and there are accommodations. I want to talk about those things separately. The mandate does not apply to certain categories of workers. And I don't think this has gotten a lot of coverage, but there are some categories of workers that it doesn't apply to. Now, as Nancy referenced earlier, these employees still have to be counted when you're determining whether you employ 100 or more employees, so they count, but they may not be subject to the mandate. So there are a few different categories. First category that this does not apply to is individuals who don't report to a workplace where other individuals are present. So there are no coworkers, there are no customers. There's a separate category for working from home. So this is they report to a workplace, but no one's there. I struggle a little bit to try to figure out what that exactly looks like. Maybe they're in a warehouse, a small warehouse facility by themselves. I'm not sure. But that category is exempted from the requirements. The mandate also does not cover employees while they are working from home. So if you've got somebody working exclusively from home, then they are exempted from this. However, if they work part-time from home, if that changes, if they have been working from home and then come into the office, then you're going to have that mandate apply. So that can be a very much a moving target. Also exempted from the mandate are employees who work exclusively outdoors. And there are a few caveats to that. What does that mean? Well, the employee has to be outdoors all the time. It has to be all the days, not that they work indoors some days and outdoors the other. They also can't share vehicles with other employees. So if they have an outdoor work site, but then they jump in a car to go to a different work site with other people, then they are not exempt from this. And the employee must work outdoors for the duration of every work day, except for maybe just some very de minimis use of indoor spaces, like they come in to use the restroom or they go home for lunch. Certainly, I think if they would come into the workplace in a cafeteria to have a lunch break there, then they would not fall within this exemption. But these categories of workers, they count towards your 100, but the mandate does not apply to them. Now, in addition to exemptions, you're going to have to deal with some accommodations. And we know that employees have been talking a lot and employers have been talking a lot about what do these accommodations look like? Can they be used proactively? Will people try to use them proactively to get out of this? So I think it helps to start with just that basic understanding and reminder that employers must provide reasonable accommodations to those employees who either have a medical condition that might preclude the vaccination, and we'll talk about that in a minute, or if they have sincerely held religious beliefs or practices that conflict with the vaccination requirement, as long as the accommodation does not impose an undue burden on the employer. Now, undue burden here looks a little different than what you're used to in terms of the ADA process, but it's a little bit unclear really what that will play out as in terms of the undue burden. But let's talk first about medical accommodations, and this transcends beyond traditional ADA type of accommodations. You may have ADA accommodations. A person might have a disability that their doctor says makes the vaccine improper for them to be subjected to, but it might just be also a contraindication, and the ETS speaks to that. So contraindications are really more transitory for the most part, could be permanent, but oftentimes more transitory. Could be that the employee currently has a respiratory issue or is a suppressed immunity that might impact their ability to receive, or the wisdom of them receiving the vaccine. But again, it could be also a broader ADA issue. So this is something that could be short-term. This could be something that is an accommodation that will last throughout the term of the ETS. If a medical accommodation comes up, the employee should be asked to provide the appropriate documentation, just like you would with other accommodation issues. You'll want something from the healthcare provider that explains the nature of the impairment, the duration of the need for the accommodation, and the extent to which the impairment conflicts with your vaccination requirement. And just remember that if you do need to consult with a healthcare provider, you're going to have to go through the normal hoops. You need to get written medical release or permission from the employee, and the healthcare provider should not disclose information or answer questions about the employee's underlying disability or medical condition without his or her permission. You just need to know the duration, the extent that impairment is going to conflict with the vaccination requirement. You should be looking at putting together some forms. As with anything, you need to make sure that you have a point person or a point committee that is handling all of these accommodations, so that number one, they're doing it the proper way. Number two, you're treating employees consistently and not looking like you're playing favorites with any of these issues. So very important that you think through this as you're putting your process together. I think the more difficult accommodation that employers have been facing and will continue to face are religious accommodations. And I think these are more difficult for a couple of reasons. First of all, traditional EEOC guidance says that religion looks like a wide variety of things. It's not just that someone goes to a traditional church, that they are this religion or that religion, but the EEOC says religious beliefs may mean that there might be only one follower, or it could be a religion that seems completely illogical to you or unreasonable to the outside world. But if it's a sincerely held religious belief, that counts in terms of providing accommodations. What does not count is just a personal a social belief, somebody who just doesn't like vaccines, they think they're politicized, they don't think that they've been tested properly. Those are personal beliefs. Those don't fall within the religious accommodation category, and you don't have to accommodate those. And again, when you're preparing forms, and you should have some forms that are used for employees to fill out, you should have sections that require the person to identify whether this is a personal or a social belief as opposed to a religiously held belief, and you want to work with counsel in determining what questions are appropriate to ask and what are not. But digging in a little more deeply on the religious accommodation issue, because it's so very tenuous, really once you receive a request based on religious belief or practice, you should assume that that belief is sincerely held unless you have some objective basis for questioning either the religious nature or the sincerity of the belief. I mean, look, if you had an employee who before these things came out and said, well, if you try to force me to get a vaccine, I'm just going to tell you I have a religious objection. Maybe that's an objective basis for questioning the religious belief. But we're seeing a lot of employees hear the words, religious objection. Maybe this, does truly apply to me. Maybe this is a means by which I can avoid the vaccination. So it's something that's really going to require some navigation. with regard to the assessments, when somebody comes forward, even though prior inconsistent conduct may raise a question regarding the sincerity of the person's belief or practice, the EEOC does recognize that beliefs may change over time. So therefore, requests that may be sincere now may seem inconsistent with a certain belief in the past. So that's another wrench that's thrown at you. Most assessments of religious accommodation requests really will likely hinge at whether or not they would cause your business an undue hardship. At this stage, what the EEOC says is that you can consider not only the costs, what is it, physically, what is it costing you in terms of financial immediate repercussions, but also you can consider the risk of the spread of COVID-19 to other employees in the workplace or to the public. You should consider each request on the basis of its specific factual context. So therefore, what the EEOC says is granting or denying one request doesn't necessarily mean that another request would result in the same result. And significantly to you, although there's really an assumption that many more employees may seek a religious accommodation that in the future, that's not alone evidence of an undue hardship, though the EEOC recognizes that you may need to take into account the cumulative cost or the cumulative burden of granting accommodations to many other employees. So if you have an onslaught of these kinds of requests, then you're going to get into a different type of undue burden analysis. Part of the consideration too for employers for a practical matter, and I think this question is largely unanswered, is what happens the next time? I've seen some very public comments from some employers who don't like the mandate, who say, well, anybody who brings to me a religious exemption form, I'm going to grant it. I guess there's a question of how are the agencies going to view that if 90% of your workforce has exemptions. The other question is what happens the next time? So if a particular employee comes forward and says they have a religious belief that precludes them from taking the vaccination, then does that impact your analysis if they come forward in 2 months' time and say, you know what, my religious beliefs now prohibit me from working overtime or from working on Saturdays? So again, something that requires some forethought, something that requires really some analysis, and a real need to make sure that you are having a centralized decision-making on these requests and how they apply not only now, but what implication they may have in the future. Another thing that you need to be doing now is taking a look at the policies and documentation that the ETS requires. And these are things that are going to take some time to put together. So the documentation requirements, there are numerous. There are certain policies that you have to put together, written policies, and very specific requirements for those policies. You also have to provide some notices to your employees separate and apart from those policies. And you have some very clear requirements in terms of the documentation, employee documentation that you have to receive. So let's talk first of all about your policies. There are very specific things that must be included in policies that you have to develop. So those are your requirements for the COVID-19 vaccinations. How are you requiring this? What are your logistics? What are the deadlines? You need to make sure that you're identifying those applicable exclusions, the things we talked about. If you have categories of workers who are excluded, you need to identify those. Even if you don't have those specific categories of people, you should be identifying those exclusions in your written policy. You need to provide within that policy information on determining an employee's vaccination status and how this information will be collected from the employee, what the procedure is for doing that. You need to include that paid time off information, the information about paid time off to obtain the vaccine, paid time off in the event of any side effects of the vaccine. You need to provide information about notification to the workforce of when there are positive COVID-19 tests and your procedure for removing COVID positive employees from the workplace. You need to include information that's going to be provided to employees, like how are you going to make that information available to the employees? I would recommend that you have multiple avenues for employees to get that information, probably written, maybe on a portal, a variety of ways that employees can get that information. And this policy needs to set forth what happens to employees who don't comply with your policy. You need to make sure you are identifying the disciplinary action that they face if they are not following the policy that you outline. Other considerations for your policy is you need to make sure you're talking about what's the effective date, what's the duration, what are the deadlines for all of the things that employees need to do and that you need to do as an employer, enforcement, and who that policy applies to. In terms of verification and record keeping, employees do need to provide you with that proof of vaccination, and that can look like a few things. But first of all, let me talk about why it's important to have this. So those FAQs say that you're going to have this process in place. So you're going to have to make sure you have these records, that they're stored in a way that you can get to them. Because if OSHA comes knocking at your door or gives you a call and says they want your records on your vaccines, your proof of vaccines and your testing obligations, it's a 4-hour turnaround for you to provide that information. And I think that's likely the way that OSHA is going to get around some of the enforcement hurdles. They're not going to be able to send agents out to every employer, but they could start making a lot of calls and say, we want your information on your record keeping, on your proof of vaccine, et cetera. So you've got to have those organized and handy and know how to access them and know how to provide those. But in terms of proof of vaccination, employees also actually have a variety of means that they can provide you proof. They can provide a medical immunization record from their healthcare provider or pharmacy. They can provide a copy of the vaccine card, records from a public health information system, other official documentation like their doctor's records. And if no such documentation can be produced, and I actually kind of surprised that there's this loophole in here, if that documentation can't be produced, the employee is permitted to submit a signed, dated, and sworn attestation that they have the vaccine, that they acknowledge that if they knowingly provide false information, they could be subject to criminal penalties. I would suggest that seems to be, you're going to want to really rely on the other forms of documentation other than that, but that is a means that's set forth for employees to provide verification. Now, not only do you need to keep records with regard to the vaccines, but employers also have to keep records of those COVID-19 test results. That's each one of those. So every test result that's being taken needs to be maintained by you as the employer. You only have to maintain them during the duration of the ETS. So if indeed it expires in 6 months as currently outlined, then you don't have to continue to maintain those. But while you do, you should treat them like any other medical record, keep them separate from the personnel file, share them only on a need-to-know basis, and make sure you're ensuring privacy. Now, I talked a few minutes ago about the employee notice requirements. So covered employees also have to be given very specific notice about a variety of things. First of all, you have to inform them about the benefits and safety of being vaccinated. You as the employer have to provide this information to them, and they're suggesting that you provide the CDC document, key things to know about COVID-19 vaccines. That's available online. That's what's recommended that you provide to employees to provide information about the vaccination. You need to, in that notification, you need to outline the requirements of the ETS and your workplace policies and procedures to implement it. You need to identify in that notice that there are protections against retaliation and discrimination. And you also have to provide them specific notice that there are criminal penalties for knowingly supplying false statements or documentation. So if they provide that attestation and it's false, if they give you a fake vaccine card, you have to provide them information that outlines the criminal penalties for that. OSHA has a sample fact sheet that you can check that box by providing to them. It's called Information for Employees on Penalties for False Statements and Records. And it does a pretty good job of, I think, scaring people by pointing to things like $10,000 penalties and potential jail time. So that's a recommended document that you could use to provide to employees to satisfy that particular notice requirement. And I touched on OSHA enforcement, but I'm going to turn it back over to Nancy to talk a little bit more about that area.
Great, thanks so much, Debbie. Yeah, OSHA enforcement. So one of the things that I think has been really difficult for a lot of our clients is that for those clients who are not in sort of a typical OSHA heavy sector in our economy. So those of you who are in the construction industry or you're in a manufacturing environment, you're a little more used to what happens when an OSHA inspection happens. You're used to sort of dealing with OSHA related issues. For those of you who operate in more of an office environment, dealing with OSHA may not be something that you are as familiar with. And so this is something that's, sort of a rude awakening to have this be your real first introduction to OSHA. But as Debbie said, our anticipation is with these really short turnaround times that this is sort of going to be used as a screening process by OSHA to determine who has got their ducks in a row and has really done all the things they're supposed to do as far as policies and documentation, et cetera, and who doesn't. And not having your ducks in a row and having the appropriate documentation or turning it around in the time that's required would potentially subject you to these penalties, but it also will likely subject you to additional follow-up to determine what efforts you are making and where there are violations potentially in your workplace. We also anticipate, again, OSHA's not going to have the inspectors to be able to show up in every workplace in America that's got more than 100 employees, but we do anticipate that there will be a lot of complaints from employees, both employees who think that some of these guidelines are ridiculous, as well as employees who think that they're not being enforced by their employer. And so OSHA likely will be responding to complaints that are lodged by employees. Some things to be aware of is, anytime you're dealing with OSHA, they have significant penalties that are available on a per violation basis. Currently at $13,653 per violation. And that's something I believe is adjusted for inflation, so it likely would go up in 2022. OSHA has a lot of discretion in terms of deciding whether to issue a citation, what the amount of fines and civil penalties are, abatement directives. So obviously good faith compliance, showing your general compliance with the standard, even if there are a few potential gaps in what you've done, certainly will go a long way, but a complete disregard for the standard, or my prediction would be if you've not really taken steps to adhere to the standard and it goes into effect with a day or two's notice given the litigation that's pending, that's not going to be seen as an excuse for failing to comply with OSHA standards. And there is a tenfold penalty that OSHA can exact on top of this for continued violations. So these things can become quite costly very, very, very quickly. And again, a willful violation, just for those of you who really don't deal with OSHA that often, a willful violation exists where the employer has demonstrated either an intentional disregard for the requirements or plain indifference to employee safety and health and the requirements of OSHA. So again, if there are issues related to some testing issues, timing, getting test results, someone has taken the test the week before, but the test result was delayed by a single day. I can't predict what an OSHA inspector would say, but it seems to me that that would be an example of good faith compliance. If you have an entire file full of employees who are all routinely failing to get their results back to you within that 7-day period, that is going to look more like a disregard for the standard. A serious violation of OSHA exists if there's a substantial probability of death or serious physical harm that could result from the condition which exists, or from one or more practices, means, methods, operations, or processes which have been adopted or are in use in that employment, unless the employer did not or could not know with the exercise of reasonable diligence know of the presence of the violation. Again, much of these issues related to vaccination records, testing, ensuring that you have the appropriate documentation. These are things that the employer is going to have within the exercise of reasonable diligence to know whether or not are your employees, getting their tests and turning in their results on a every 7-day basis. These are things that you're supposed to be monitoring. Are you paying attention to whether or not unvaccinated employees are masked in your workplace, or are you just kind of like, you see everybody not wearing a mask or having it hanging around their neck and not covering their nose and mouth, and are you just sort of looking the other way? Those are things that are not going to put you in very good stead with the OSHA inspector if that person shows up. So just be very cognizant of the need to do what you can to dot the I's and cross the T's and put processes in place to ensure that your organization and your supervisors and managers are aware of what their obligations are and how to adhere to the applicable standard. So good faith efforts. If there are supply issues with testing materials, now OSHA, when it issued the ETS, it sort of suggested that they don't anticipate that there are going to be any problems with testing supplies, laboratory capacity. I'm sure OSHA knows more about it than I do, but I'm not so sure that that's going to be the case. But if you do have specific issues with supply chain, with laboratories getting backed up, et cetera, you are going to want to document your good faith efforts in attempting to comply with the ETS. So, showing that your employee, let's say their test result is due every Monday, the employee went in on Tuesday or Wednesday, and maybe in the past, getting a test on Tuesday or Wednesday, they always had the result by Monday, but this week that didn't happen, or the past 2 weeks that didn't happen because the lab is now backed up with a 6, 7, 8 day backlog. You want to demonstrate that the person is actually going and getting the test, that you're following up, that you're keeping track of all of this. Those are issues that will hopefully help you in the event that you're called to account for a failure to meet those requirements. Okay, some practical tips and questions before we go on to some other topics. First of all, hopefully this presentation, if you've learned nothing else, hopefully you have learned from this presentation that you really cannot wait for this pending litigation to be resolved before you at least start making plans. If you don't want to announce a policy to your employees, if you don't want to decide necessarily about whether you're going to go with mandatory vaccination or a testing alternative, et cetera, you can at least start putting together paperwork, start putting together policies, have a communications plan ready to roll out so that if the ETS is not stayed, or if only a portion of it is stayed or limited, you are ready to comply with those things that do go into effect and impact your organization. If you joined our last webinar when the Biden plan was originally announced a little more than a month ago, I told you, and I hope you listened to me, have you figured out how many of your employees are vaccinated? That is something that you, in my opinion, desperately want to know so that you can take a good guess at what is going to happen if we have a test option for everybody who's unvaccinated. Talked to a client yesterday, 90% of their workforce is vaccinated already. If they have to do testing for those who are unvaccinated, it's not going to create a huge problem for them. I've talked to another client who's less than 50%. Testing for unvaccinated employees for them, going to create some significant hurdles. So if you do not know where your employees fall on that spectrum, that is something that you definitely want to find out now. If you're in a position to do so, even if you don't want to issue your policy yet, have your decision makers decide, what are we doing here? Are we going to do a mandatory vaccination, or are we going to have a test option for everyone, or just a test option available for those who have a legal accommodation? There's lots of considerations. There's not a one size fits all right answer for everybody. because this is going to depend on your workforce. Many of our clients, probably most of them, are dealing with recruitment and retention issues. If you have a large swath of your workforce or your potential demographic who are unvaccinated, having specific requirements to be vaccinated is really going to limit your pool of talent. What is your percentage that are already vaccinated? The locations where your operations are. What's the availability of tests? Are you in a rural area, an urban area? What is your sense of that, and how can you do the testing? Is it going to be something where you have something in a remote location? Are you really going to need to do testing on site, because that's really the only way to get this done in sort of an expeditious manner? Do you have key talent who's made it very clear to you, if I have to get vaccinated, I'm out of here? If that's something that's going to have a huge impact on your organization, that's certainly something you may want to factor into your decision. And then obviously the applicability of other standards. And by that I mean, and I'm sure that we're going to see more of this, there are some states that have specifically passed laws that say that you cannot have a vaccine mandate. For example, in Texas, we expect to see that also in some other southern states. Louisiana, Georgia, Florida, Alabama, Mississippi have all talked about this. Not to get into the weeds on federal jurisdictional issues, but the ETS does preempt states from having those sorts of workplace requirements regarding not allowing employers to mandate vaccination. But that's going to be, a legal challenge between what a state or a governor does versus the ETS. And then you add to that some issues with the states that have their own state OSHA instead of the federal OSHA. And so it all becomes quite complicated, but obviously the location where your facilities are located and any applicable currently pending state laws would be something that you would potentially want to consider as well. Important to proactively communicate with employees. I am sure you are already hearing from your employees, what are we doing? What's the policy going to be? Are you going to force us to be vaccinated, et cetera, et cetera? It's really important to say to employees, and they may not want to be patient. No, everybody is getting very impatient, but the reality is to communicate with them, we're working on this, we haven't decided, we hope to have a decision by whenever, letting them know that you understand that these are very important issues and that you're working on them and that you're going to keep them in the loop when a decision is made. Important, again, as Debbie covered, drafting policies and processes, getting those in place, thinking through what are the ramifications for non-compliance. Are you going to discipline people? Are they going to be fired? Are you going to suspend them? Some companies who already have mandatory vaccination in place give people sort of a purgatory where they say, okay, you're not vaccinated by the state, we're going to put you on unpaid leave to kind of think about whether you want to change your mind. And then they say, if you don't change your mind in whatever 2 weeks, then you're terminated. So thinking through those issues. Obviously, getting ready. Designate a compliance point person or committee, somebody who is going to be a consistent communicator, decision maker about these issues. Have a testing plan. As I said before, OSHA says they don't expect any testing supply or lab problems. I do. We'll see who's right in a couple months. I'd put your money on me. So think through that. Create an accommodation process. Really important to have this documented, to be consistent, to have some level of rigor. Especially if you're a federal contractor, if you are just willy-nilly approving every single religious exemption that doesn't look like a sincerely held religious belief, that could potentially put your government contract at risk. We don't know how strictly that is going to be enforced or what sort of paperwork they're going to look for, but that's something that could be a concern. Training supervisors and managers. Most of them have, we've never dealt with these issues, so your supervisors and managers probably haven't dealt with these issues. Having them understand, maybe they have access to vaccination records so that they know who has to wear a mask, who doesn't, things of that nature. They need to understand that that is on a need-to-know basis. That is confidential information. They need to know what questions to ask, not to ask, or if somebody raises a question with them, who they should say, you should go call this person because they're the ones who are handling this process. And then finally, big thing, especially for those of you who are not in an environment that usually deals with OSHA, do your employees know what to do when OSHA comes knocking? There are specific things that OSHA can and cannot do. But of course, if your receptionist says, come on in, let me show you down to the file room, I mean, they're going to go ahead and do that. So you need to be thinking about some training and maybe just a quick refresher for people who maybe haven't dealt with OSHA in the past to think through what should they be doing if OSHA is knocking at the door. So with all of that, as if you don't have enough to do, I'm going to turn it over to John Weimer, who's going to talk a little bit about some of the special issues that you have to think through if you work with unions or have a collective bargaining agreement. John? John, you may be on mute. Okay, we're still not hearing John, so I'm going to give him a second to deal with maybe a technical issue that he's having. I will say I am looking at our questions. Thank you for everybody who is participating and sharing questions. We're seeing a lot of things. We will try to get to these towards the end of our presentation. I see a number of questions from people who probably joined a little bit later. We are going to be sharing this webinar is being recorded, and we are also going to be sharing the recording as well as the slides within the next day or two. So you will be getting those for anybody who registered for the webinar. John, are you with us now? Okay, while John works through his issues, I'm going to go ahead and move forward to the benefits related questions that Kim Wilcoxon is going to be talking about so that we can go ahead and cover those, and then hopefully John's issues will be resolved in the next 5 or 10 minutes. So Kim, I'll turn it over to you.
Great, thanks Nancy. Next slide, please. So there's two aspects of benefits issues that we want to talk about. One is COVID-19 testing, and one is COVID-19 vaccinations. So under group health plans, non-grandfathered group health plans are actually required to cover the cost of a COVID-19 diagnostic test and the related office visit. So if you go to a doctor and the doctor says you need a test, the office visit gets paid as well. That gets paid at 100% without deductible, co-payment, cost, any other cost sharing. But the group health plan is not required to cover COVID-19 tests that are conducted for employment purposes. So if you implement a testing program in connection with the ETS, that testing that your employees are doing solely to come to work does not have to be covered under your group health plan. Now, in addition to what the group health plan is required to cover, the IRS and DOL gave us some guidance that says if you do provide testing under an employee assistance program, you can do so without causing the employee assistance program to lose its accepted benefit status, which means that's something you can offer to all employees, not just employees who are in your medical plan, without triggering Affordable Care Act rules. Similarly, you can provide COVID-19 testing at an on-site medical clinic. Next slide. Similarly with the vaccine, group health plans are required to cover the cost of the vaccine and its administration without cost sharing. There is no exception for vaccines that somebody gets just to come to work. If the person's getting the vaccine, it's covered under the group health plan. And like testing, we can provide vaccines under an employee assistance program, and we can provide vaccines at an on-site medical clinic. Now, the reason why I've sort of highlighted these issues, next slide, is because employers may be considering paying for COVID-19 diagnostic testing or the vaccine outside the medical plan. And if that's the case, does that create a new ERISA group health plan? So a group health plan under ERISA is an ERISA plan that provides medical care. And medical care are amounts paid for the diagnosis, cure, mitigation, treatment, or prevention of disease, or for the purpose of affecting any structure or function of the body. COVID-19 testing would seem to be medical care because it is diagnosing whether an individual has the disease. The vaccine would seem to be medical care because it's prevention of disease. But is there an exception for a program that's put into place solely for workplace safety purposes, or solely in response to this government mandate. We were really hoping that the ETS would have guidance that says, no, this is not an ERISA plan. If you put this into place solely to comply with this mandate, you don't have to worry about ERISA. Well, they didn't. They didn't address it at all. So we're still in somewhat of a gray area. Now, I want to take just a moment to pause and say, if you are not considering the testing program, but you are considering providing vaccines outside the health plan, there may be an argument, depending on how you set up that vaccination program, that that program's not subject to ERISA because there's no ongoing administrative scheme. We're not going to get into the detail of that today, but if that's you, consult with legal counsel to see if sort of that's an out for you. But back to the original question of, if we pay for testing or vaccines outside the health plan solely for workplace safety purposes, do we get an exception? Next slide. And a lot of employers say, well, what about drug testing? I mean, drug testing, mandatory drug testing is not an ERISA plan. And that's because we have some guidance from the Department of Labor on drug testing, where the Department of Labor looked at a drug testing program that was done solely to determine whether an individual was eligible for employment. And the Department of Labor said, well, you're not providing any sort of counseling or care in connection with the drug screening, so it doesn't look to us like this is medical care. I will say that drug testing seems to be distinguishable from COVID-19 testing. Drug testing may be determining whether you have ingested a substance, whereas COVID-19 testing is determining whether you have a disease. So, can we rely on that drug testing guidance? We don't have guidance to confirm, is what I'll say at this point. I think if you're considering relying on that, you need to talk to legal counsel about the potential risks. Next slide. Assuming you want to be, better safe than sorry, or take a conservative approach, or if you believe that the law requires this, if we're treating a COVID-19 testing or vaccination program as an ERISA plan, we have to think about how to comply with the various ERISA rules. So there's a written plan document requirement. There's got to be a summary plan description that describes the benefit. You've got to report the benefit on a Form 5500. Now, those compliance requirements are fairly easy to address, especially with an employer that already has what we would call an ERISA wrapped plan that wraps together, a number of different ERISA governed health and welfare benefits. Other issues, though, may be a little bit more difficult to address, such as COBRA. If your testing program is subject to COBRA, then somebody who terminates employment no longer has the ability to get tested. Do they need to be offered COBRA? Does that COBRA, if this is offered to all employees and not just employees in the medical plan, do you have an additional COBRA notice obligation? How are you going to determine a COBRA premium? Would you just continue to make the testing available after termination of employment to avoid COBRA application? It's not a great situation to be in to try to apply COBRA to a program like this. I think there are some creative ways to do it, but again, it's going to take some thought. Now, HIPAA, we've got two different sort of HIPAA aspects here. One is non-discrimination, which is your special enrollment. Those rules probably are not going to apply, because if you provide a COVID-19 testing or vaccination program outside the group health plan, then you could probably treat it either as an EAP, as we talked about earlier, which is exempt from the HIPAA non-discrimination rules. Or you could treat it as an on-site medical clinic if all of the testing and vaccinations are being done on site. Now, if it's being provided as an EAP, the HIPAA privacy rules are going to apply. And so you're going to need to think about how to address HIPAA compliance with that program. If it's provided as an on-site medical clinic, the HIPAA privacy rules would not apply. So if you can get all of this done on site, your liability could be limited a little bit. And then with the ACA, if we can provide the program as either an EAP or an on-site medical clinic, we don't have to worry about the ACA rules that require a group health plan to cover all aspects of preventive care. So I think that one is fairly easy to get around as well. Next slide. So let's assume that, absent, completely independent of the ERISA issues, what if you are considering incentivizing employees to get the vaccine? Incentivizing them could very well cut down on your testing program administration and costs if you decide to have a cost for that. So, employers may be thinking about vaccines to encourage people or incentives to encourage people to get vaccinated. And I'll say if that's something you're considering, we need to think about the design of the program to determine which rules are going to apply. So the first thing to think about is the incentive available solely upon proof of the fact that the vaccine has been administered, or does the vaccine have to actually be administered by someone with whom the employer has a contract? In order to get the vaccine, do you have to come to our on-site clinic and get the vaccine from our, partner? And then will the incentive be offered as part of a group health plan? Next slide. So let's look at a couple of examples here. The first example is, let's say a gift card is available if an employee simply shows proof of administration. This, I think, is the easiest sort of incentive to administer. Go ahead and click, Nancy. Because we don't have to worry about ADA or HIPAA wellness program rules that could limit the amount of the incentive. Click again. Because COVID-19 vaccines are not considered medical examinations under the ADA. Next. And proof of vaccine requirements are not likely to elicit information about a disability. So we don't have the ADA rules that apply. Next. And if the incentive is not provided in connection with a group health plan, as here, we don't have the HIPAA wellness program rules. So this is the easiest, cleanest way, a gift card or cash in exchange for proof of vaccination. That's probably the cleanest way to go. Next slide. Let's say cash is available if the vaccine is administered by a provider under contract with the employer. So we've brought in, a vaccination provider. You come to our clinic, you get the vaccination, we give you the cash. In this case, the ADA rules would apply. Next, click. Because that provider who's administering the vaccine has to ask some pre-vaccination screening questions. And those are likely to elicit information about a disability. So we've got disability-related inquiries, and we have the ADA wellness program rules. Next click. If the vaccine can't be mandated under the ADA generally, then we have to comply with those wellness program rules. Next. The problem with the ADA wellness program rules is that there is no safe harbor to determine how much of an incentive you can provide. So we know that the incentive can't be so substantial as to be considered coercive. So for example, if you would say, for those folks who get vaccinated, we're gonna give you $30,000, right? Somebody who doesn't get vaccinated loses out on $30,000. That's probably considered a penalty. But if we say, if you get a vaccination through us, we'll give you a $5 gift card. That's probably not gonna be considered so substantial as to be coercive. But we have no sort of guidelines to tell us how much and how little are acceptable. Next slide. So here's something that has become relatively popular recently, which is thinking about a premium surcharge that applies to medical participants who don't provide proof of vaccination. Next. So in this case, we do have HIPAA wellness program rules that are going to apply. And so we've got an activity-only wellness program, which means that the incentive, the surcharge, when combined with all other incentives for health contingent wellness programs, can't exceed 30% of the cost of coverage. Next. In addition, you have to make a reasonable alternative or waiver available for individuals for whom it's unreasonably difficult due to a medical condition or medically inadvisable to obtain a COVID-19 vaccine. Next. So for example, if somebody can't get the vaccine because it's medically inadvisable, they could still avoid the surcharge if they comply with the CDC's mask guidelines. Next. Where reasonable, so if it's not obvious, you do have the ability to ask an employee to provide verification that they are entitled to this alternative because it's either unreasonably difficult or medically inadvisable to get the vaccine. Next. And if the employee's personal physician states that vaccination and reasonable alternatives are not medically appropriate, so the thing that you've proposed, the physician says, no, that's not right for this employee, then you have to provide an alternative that accommodates the recommendations of the physician. Next. And any materials describing the surcharge have to include notice of the availability of that reasonable alternative, including contact information for somebody who wants to request one, and a statement that we are going to accommodate the recommendations of their physician. Next slide. Go ahead. Then the program has to be reasonably designed to promote health and prevent disease and can't be a subterfuge for discrimination, which means the program itself can't be overly burdensome. So you can't say you must go to this pharmacy on this date in order to get the vaccine. You know, there has to be some sort of way to help make the vaccine, make it easy for the employee to know where to get the vaccine and how to get the vaccine. Next. Reasonable alternatives also can't be overly burdensome. So if your reasonable alternative is, well, you must get a COVID-19 test every day, that's probably not going to work. Next. And we have to give the individuals eligible for the program the opportunity to qualify for the reward at least once per year. So there are some questions about, you know, how to implement something like this mid-year, what to do as far as next year. Do you ask people for verification again next year? So there are a lot of issues that go along with a premium surcharge program. Next slide. So for employers who are, oh, and one last point here, go ahead and click all the way through this, Nancy, is that if you have a surcharge, the amount of the premium, including the surcharge, is going to be considered the cost of the plan for ACA purposes. So if you apply a premium vaccination surcharge, your plan becomes more expensive under the ACA affordability rules. So you get to pretend that an employee, you know, is a non-tobacco user, but fails any other wellness program under HIPAA. So for the example here, if the base premium is $100, tobacco surcharge is $75, we have a non-vaccination surcharge of $100. When we're looking at ACA affordability, we're looking at that base premium plus the non-vaccination surcharge. So the cost of the plan is $200. Next slide. So for employers who are thinking about this, you know, number one, determine whether the health plan is going to cover those COVID-19 tests that are conducted for employment purposes. Because remember, it doesn't have to. If you are going to pay for the testing or the vaccine outside the health plan, determine whether a group health plan exists and how you're going to comply with those group health plan requirements. And if you're going to provide incentives for employees who obtain the vaccine, ensure that the design of the program complies with all applicable laws.
Great. Okay, I'm going to try to go back here and get back to the traditional labor presentation. John, do you have your microphone? Is it working now?
I think it is. Can you hear me?
We can hear you. Fantastic.
Yay.
Get back to your slides. Union issues with John Weimer. Have at it. Go ahead.
All right. Thanks, Nancy. Yeah, you've been asked or suggested to you that there are a lot of decisions that you have to make about how to do all of these things. And the thing to keep in mind is if you have a collective bargaining relationship, then you're going to have a partner with whom you are going to have to discuss and negotiate some of these things. Keep in mind that we have three possibilities. One is that the federal mandate applies and or the healthcare mandate, in which case obviously you have to do it. And so the only question is what the effects of it are. Under the OSHA guideline, the temporary standard, you have a choice to make or choices to make. And since that is a decision that will affect the terms and conditions of employment of others, you're going to have to probably negotiate that decision as well as the effects. Or you can have a collective bargaining arrangement where neither applies, in which case you don't have to do these things. But if you do want to do anything, you're going to have to negotiate it with the union. And so the question is, if you engage in effects bargaining, if you have to do this, if you have to require that employees be vaccinated, obviously you don't bargain over that, but what you would be required to bargain over are the effects of that mandate on bargaining unit employees, like the deadline for submission of the vax or exemption information if they claim that they're protected or don't have to get vaccinated because of medical or a religious reason. How this information is going to be stored and maintained, who's going to bear the costs, whether this will, when they're off, whether they'll get sick time, whether there'll be any attendance issues, whether there'll be a reconsideration period, which I'm going to circle back to and admit if there are any guaranteed accommodations and any sort of appeals process. But one of Nancy's slides talks about discipline. What are you going to do if people don't get vaccinated? Are you going to fire them? Are you going to discipline them? Are you going to suspend them? Whatever it may be. The point here is that also you may have a collective bargaining agreement that defines just cause for termination in some way that didn't even contemplate the COVID-19 situation and the vaccination process. So you're going to have to sit down and discuss with the union, and I think early and often, how these issues are going to be implemented and the effects of the implementation on the employees covered by the collective bargaining agreement. And my recommendation is that you engage the union early on this. One of the questions is, well, does the union have to ask to bargain? The answer is technically yes, but my recommendation to every unionized employer is you initiate the process. You tell the union what it is that you need to talk about in the implementation, as opposed to them having to request it, because you can't really implement anything until you've at least talked to the union about these issues. Next slide. Obviously, if you're not a federal contractor or you're not a healthcare entity, then you have a choice about whether you're going to require testing, whether you're going to require vaccination, or whether you're going to require one or the other. And that would be, of course, a decision that you as the employer have to make. But if you are unionized, it is a decision over which the law requires you to bargain before implementation. And so that's where you're going to have to sit down with the union and talk about the decision itself. Is it going to be vaccinate, test, or an alternative, and negotiate that with the union. The union, of course, can request information. Part of the duty to bargain that an employer has under Section 885 of the Act is to provide information reasonably requested by the union to facilitate its role as the employee's collective bargaining representative. So the union can ask you for information about, obviously, things like who's been vaccinated, who hasn't, how are you going to do this, what are the costs, how much are you spending on PTO? And as long as there's a reasonable correlation between the issue that they seek the information over and the information itself, you would have to provide it to them. Now, one question would be, well, what if we don't reach agreement with the union? Which brings up the issue of impasse. An employer is not entitled to implement a decision unless it either A, gets the agreement of the union, or B, reaches impasse, which means the parties are irreconcilably in disagreement, and there's no way that they can possibly reach an agreement. And if you reach impasse, then the employer is free to go ahead and implement its final decision or its final determination. Although what impasse is discussed on the next slide. Well, I take it back. Okay, impasse. You never know when you're at impasse. The employer typically thinks it's at impasse quickly. The union says, oh no, we would have been willing to negotiate further. The important thing to keep in mind, whether you were at impasse or not, and meaning whether or not you were entitled to implement your final offer, is something that's determined by the National Labor Relations Board. And if the union believes and argues that you have not bargained to impasse and you have bargained in bad faith, then you'll get an unfair labor practice charge, and or you may get a union grievance as well. The main thing to be able to demonstrate from the employer's standpoint is that you entered into the negotiations in good faith, meaning you wanted to reach an agreement. You listened to everything the union said. You considered their proposals. And in many cases, my view is that if you show that you were willing to compromise at least on some of the issues that the union asked you to compromise on or to change, then you should be able to argue effectively that you were at impasse. Keep in mind, you're not required to agree to anything the union says or to change your position. But again, if you start out with position A and at the end of the discussion, you enter still at position A, you've done nothing to compromise or propose alternatives, that's a harder case for the employer to show that they were at impasse, that the employer bargained in good faith. So let me, Nancy, just mention a few other things. My view is, Kim talked about some incentives, and other people have talked about incentives like, gift cards or cash or whatever. Keep in mind that anything you do that affects a term or condition of employment is a bargainable issue. So before you implement any plan to incentivize employees to get vaccinated, if you're unionized, you're going to have to reach agreement with the union. You would think that that agreement would generally be almost automatic, but it's not always true. There are some unions that are already pushing back against this. Typically, the local unions are the most difficult to deal with because they're right there on the scene and the members are saying, we don't want to do this. So you as the employer may have to go up the chain, the union chain of command, and find some more senior people who understand that this really isn't something that anybody cannot do, that it has to be done. And the only question is how you're going to do it. And then the last thing I would say is that this requirement that you talk to the union, I think it applies to almost everything. And Nancy was talking about being proactive with employees. I think employers should consider engaging employees, at least generally, in the discussions and planning about this, because the biggest problem is pushback. And the way you deal with pushback is you get people involved in the process.
Great advice, John. Thank you. We are at 1:30. I'm going to try to answer a couple of really quick questions that we got. We got many, many good questions. Thank you for that. We do not have time, obviously, to go through all of them, but a couple of quick ones I want to try to facilitate because they may apply to a number of people. Number one, you do not have to facilitate the testing. So if you have the testing option, it's not something that an employer is required to facilitate. Someone asked that question. If you have somebody who does not come into your workplace on a regular basis, they need to test and have the result. So the test had to have occurred in the 7 days prior to their coming into the workplace. Excuse me, and they have to have the result, a negative result, before entering the workplace for those people who are there intermittently. A couple people had questions about the self-administered at-home test and the use of the word both in the regs about how it cannot be both self-administered and self-read. What that means is they cannot take the test at home and then bring it in to the employer for the employer to read it, because of course the test could have been done at home on their spouse, their child, what have you. And so it's something where it has to be clear that the test is being done on the particular employee and that the reading is something that's verifiable. So that cannot happen. Neither part of that can happen at home in an unproctored fashion. We had another question about local laws that are stricter in some jurisdictions about masking requirements and things like that. While OSHA is a federal law that likely preempts state and local law, OSHA has said specifically that is focused on undercutting the effectiveness of the OSHA ETS. And so if there's a local law that is more strict, that is more protective, that is going to be okay. OSHA is really setting the floor. Something that is above and beyond is not going to be preempted by the OSHA ETS. And the final question I'll try to cover very quickly is just whether the first fine that OSHA issues would likely be with respect to a particular facility as opposed to something that is based on each employee. For example, maybe you have testing that is out of compliance for 10 employees. Would there be a fine based on each of those employees being out of compliance? Likely to be to the facility with some coaching and guidance about what has to happen going forward. If there were a repeat violation, likely the fines and the mechanism for calculating them would increase. So that was just a quick run through of some of the simpler questions. I apologize if we did not get to your particular question. We will try to get in touch with you. We will be sending the slides in today's recorded session out to everyone who registered within the next 1 to 2 business days. So please be looking for those in your email. If you have questions that we were unable to get to today, please feel free to email or call your regular Thompson Hine attorney or any one of us who presented today. If you are not a current Thompson Hine client, please again contact one of us and we'll discuss options with you to address your needs. Thank you again so much to our presenters and to all of you for attending. Have a good day and stay well.